Good day, Crime Talk aficionados. We have another great show for you to start the month of July. First, Bryan Kohberger is going to accept a plea deal and avoids the death penalty in the Idaho murder case. Morphew makes his appearance in a Colorado courtroom. Sean Combs' jury reaches a partial verdict. Both sides say give an Allen instruction. An attorney goes down for theft. We have this day in legal history when federal taxes were declared unconstitutional. Our legal quote of the day has to do with a deadlocked jury, and our dumb criminal of the day, spike the booze, not the ball. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, hit that little bell for notifications, and yes, you can check us out on any of your favorite podcasting apps. Before we get to the docket, let me remind you to go to CrimeTalkSearch.com and sign up for a background subscription service today. When you do, you will be able to do a background search on just about anybody here in the United States. The report is literally prepared while you wait, and you're going to get a plethora of information, everything down to phone numbers, email addresses, social media presence, whether they own property, are they leasing property. You're going to find out, well, if they've got car loans. You're going to find out if they're married. Are they divorced? Do they have judgments against them? Yes, and criminal history, and whether they're on a sex offender registry. So go to crimetalksearch.com, sign up today for somebody, to check them out. Maybe you just don't like them. Maybe you do like them, but you want to be sure. Maybe they're not giving you that warm, fuzzy feeling, or maybe they're just creeping you out. Go to crimetalksearch.com and check it out. Give yourself peace of mind. You're going to be happy that you did. All right, ladies and gentlemen, it is Tuesday, July 1st. Boy, anything going on in relation to criminal cases? Can't think of much, can you? Oh, that's right. Yesterday afternoon, we brought it to you live. When we went live and we talked about it for almost 2 hours about the Bryan Kohberger fact that he is going to accept a guilty plea. That is the breaking news. So yes, Bryan Kohberger, the now 30-year-old former criminology PhD student accused of the November 2022 murder of 4 University of Idaho students, has agreed to accept a plea deal that spares him the death penalty in exchange for pleading guilty to the murders of Kaylee Gonsalves, Madison Mogan, Xana Kernodle, and Ethan Chapin, as well as the burglary charge. Mr. Bryan Kohberger will serve a life sentence without the possibility of parole. Actually, multiple life sentences without the possibility of parole. But let's face it, after the first one, it's really doesn't really mean much of anything. Now, the plea is set to be formalized at a hearing on Wednesday morning there in Ada County, also known as Boise. That's right. And this is the order that has come out. Tomorrow, 11 a.m. Mountain Time. Come here. Come to Crime Talk. We'll bring it to you live, all right? And we will see how the plea goes for Bryan Kohberger and how Judge Hippler is going to conduct the hearing. All right. Now, there is a small chance that the judge could reject the plea agreement, and I say pretty unlikely. A judge's job is not to get involved in plea negotiations. This is a negotiation between the prosecution and the defense. I have it on good word that it was the defense that went groveling to the prosecution for a deal. And for whatever reason, the prosecution said, yes, let's do this. And guess what? We're going to do it. Strike while the fires are hot, so to speak, and get this matter over with. Now, ultimately, Kohberger came to the prosecution. Prosecution said, yes, we will extend that offer for death if he's absolutely certain that he will, in fact, take it. Now, the prosecutor stated that the agreement ensures that a conviction for the crime, obviously, and it spares the victim's family the prolonged uncertainty of appeals and post-conviction process, which could take literally up to the next 30 years, ladies and gentlemen. And even then, it's almost unlikely that anyone will actually be put to death. So, this resolution is our sincere attempt to seek justice for your family. Prosecutors wrote in a letter to the families, emphasizing that the deal guarantees that Kohberger will spend the rest of his life in prison. Now, remember, ladies and gentlemen, yes, there is a Victims' Rights Act, but it only means that the families must be consulted. And they can certainly air their disagreement, but at the end of the day, the prosecutor is the one that has the ultimate say on how to proceed. That's it. Victims' rights, you're consulted. You don't have super veto power. Sometimes I was talking to a district attorney today, in court, and he says, we were talking about this particular case. He says, VRA is such a pain in the butt on even just a small case. Can you imagine what it's like on a quadruple murder? Yes, actually. Yes, I can. But anyway, the point is, it's the DA's call. Now, for those who aren't familiar with the case, the murders occurred in an off-campus home there in Moscow, Idaho, and it obviously shocked the community of approximately 25,000 residents. Now, Kohberger allegedly, until tomorrow, stabbed the 4 students, Gonzalez, Mogan, Kernodle, and Chapin, while they were likely asleep. Evidence linking Kohberger to the crime scene include DNA found on a knife sheath, just like this one. Bryan, not going to brag, but I've had this one since 1986. You lost yours within 6 months of buying it. Anyway, there was also cell phone data placing Mr. Kohberger near the residence of the victim's home multiple times. And then we have security footage of his white Hyundai Elantra circling the neighborhood on the night of the killings and then speeding away as well. There's 2 other roommates in the house that survived the attack, and Kohberger's defense team had faced some recent setbacks, including the judge's ruling that dismissed their attempts to introduce alternate suspect evidence, and the judge noted as, quote, wild speculation, end quote. So with their defense strategy weakened, they approached prosecutors last week to negotiate the plea deal. Like I said, plea deal tomorrow at 11. Now, while the plea deal avoids a painful trial, some family members of the victims expressed extreme frustration with the process. The Gonzalez family in particular criticized the prosecutors for not consulting them adequately before finalizing the agreement, describing the notification process as an email with an attached letter, and we weren't even called about the plea, they stated, urging the judge to reject the deal. Now, Xana Kernodle's aunt, Kim Kernodle, also voiced disappointment, noting that the prosecutors claimed that the deal was to spare families from seeing the graphic crime scene evidence, though she felt this was not their true intent. So despite the dissatisfaction, Madison Mogan's father, Ben, expressed some relief, stating that the plea deal allows his family to avoid reliving their trauma through the trial. The Gonzalez family, however, remain concerned that Kohberger may seek to capitalize on his notoriety by writing a book or communicating publicly about his crimes, as the plea agreement does not prohibit such actions. And frankly, I don't think the judge could impose such conditions. So they said, quote, we have a killer who wants a show, and they just gave him one, said Steve Gonzalez, Kaylee's father. Obviously, this case drew national attention, culminated in the arrest of Bryan Kohberger there in Pennsylvania 6 weeks after the murder. And then the police, using genetic genealogy, cell phone data, and surveillance footage to build their case, ultimately led to this guilty plea. Now, while no motive has been established, the prosecution's evidence, including Kohberger's purchase of a scarf that was believed to be worn that night, a K-bar knife months before the victims, was deemed sufficient to secure a guilty verdict in the minds of the prosecutors and apparently of the defense attorneys as well. So we'll bring it to you live tomorrow, ladies and gentlemen, and we'll see. Now let's go through here. All right. The plea deal should be pretty specific, and we talked about this yesterday. All right. But I think it is worth noting what it is and what it isn't. All right. Yes, the judge could reject a plea deal. I've had judges reject plea deals and saying it's too soft, it's too lenient, I won't go along with this. However, it wasn't a case of such magnitude like this. But most judges don't get involved in plea negotiations. Judges are going to look and say the prosecutors know their case better, the defense knows their case better, and if they're able to resolve this case, that's good. It is finality, ladies and gentlemen. There will be no withdrawing a guilty plea. All the appellate processes are waived, and so therefore it's done. It's over. Bryan Kohberger can go sit in his little 6x8 cell for the rest of his life, ladies and gentlemen. Maybe getting out, if he behaves himself, he'll get out more than a couple hours a day. More than likely, by statute in most states, you cannot profit from a killing, like writing a book. So that would be good. And even if they did, there'd probably be a civil case where they would get a judgment against him based upon his guilty plea, right? And if he did ever write a book and make any single penny, the families would get it, which would be more than appropriate. So let's talk about the plea. The plea deal is going to state, And the judge will go over this with him on the record after the attorneys will more than likely state it. They'll say, Mr. Kohberger, you heard the proposed disposition in this particular case, right? The plea is that you are going to plead guilty to 4 counts of murder after deliberation and 1 count of burglary, and the death penalty will be taken off the table. Is that your plea agreement, right? There'll be other provisions as, no appeals, anything along those lines. If there are other specific terms like tell us exactly what you did, where's the knife, things like that, that would have to be in the plea agreement. Don't think it could be required as part of the plea agreement, but the judge could certainly perhaps inquire. All right. And I'll get to that in just a second. And the judge will ask, is this what you want to do? Is this your decision? Is anyone pressuring you? Are you under the influence of any drugs, alcohol, or street drugs that would affect your ability to understand here? And if you are on medication, how does that make you feel? If it's prescribed, does it make you feel clear? Do you understand what's going on? The judge will clarify that. The judge will then say, before I can accept your plea of guilty, I need to make sure you understand the rights. More than likely, the judge will read each count and then ask him how he will plead, guilty or not guilty. He'll then say guilty. The judge will go through that for each count, all 5 of them, and then he'll ask and state, Mr. Kohberger, before I can accept your guilty plea, I need to make sure I understand your rights. Every criminal defendant has a right to enter a plea of not guilty. Set the matter for trial. If you wanted to go to trial, it's not too late. Don't worry about it. We'll start a trial here at the end of the month, and it'll go for the next 3 months. And at that trial, you're going to get all these cool rights, okay? You're going to understand that you have the presumption of innocence. Do you understand that? He'll be told to repeat it back. The judge will ask him, do you understand you have a right to a jury trial? You'll be allowed to assist your counsel in the selection of the jury. Do you understand that? Then the judge will inquire and say, you understand that the burden is always on the prosecution to prove the case beyond a reasonable doubt. And if the jury failed to be convinced by even just one element of each charge, then it would be the jury's obligation to say not guilty. But however, if they proved your guilt beyond a reasonable doubt, they should find you guilty. Do you understand that? At a trial, you have a right to confront and cross-examine and see all evidence presented against you. Do you understand that? Yes, I do. Do you understand you have a right to call witnesses in your defense? And if you couldn't afford them, the court would pay for them to come to court, and they have the power of subpoena. Yes, I do. And the judge will say, do you understand that you have a right to testify? Yes. Do you understand you have an absolute right not to testify? And if you chose not to testify, the jury would be instructed that they could not consider your silence against you in any way. Do you understand that? And if you went to trial and you lost, you'd have a right to an appeal. Yes, I do. Do you understand that by pleading guilty, except for your right to have counsel at sentencing, that you give up all these rights? So there will be no trial. There will be no presentation of evidence, no making the prosecution prove your guilt beyond a reasonable doubt, because you are admitting to the elements. You are confessing to the elements of the crime here. Yes, I do. Understand there'll be no jury deliberation, no decision of whether to testify, and there will be no appeal now or down the road ever. Do you understand that? You're giving up all of those rights, all those appellate issues that you had for motions hearings, right? You understand that? Yes, I do. Going to inquire, are you satisfied with your attorneys? Understand? Let me know. If you're not satisfied, let me speak now or forever hold your peace. He'll say that he's very satisfied. Then the judge will advise that the possible penalty is life without the possibility of parole. So you understand you're going to get 4 life sentences consecutive to one another, plus a burglary charge. You understand you're never getting out of prison if I go along with this deal. Yes, I do. The judge can either A, say, I have reviewed the affidavit for probable cause, or the indictment in this particular case, and find that probable cause exists. Or the judge can say, now, Mr. Kohberger, before can I accept your guilty plea, because I don't want to convict an innocent man, why don't you tell me what you did in your own words? Let's just start with charge 1 and go through each one. Did you kill Kaylee Gonzalez after deliberation without legal permission or justification? Yes, I did. And how did you do it? I stabbed them, right? That's what he could go through on each and every one of them. And I hope he does, because that will make that plea bulletproof. And he will have to state in his own words, Bryan Kohberger, will have to state in his own words what he did. So for all the people that are out there, oh, he's being framed, he's being pressured, this is all a big conspiracy. If it's coming out of his mouth, I think the world should hear it. So I hope, not that I expect Judge Hippler to watch Crime Talk, but if he does, please have him state in his own words what he did for all the people out there that say that somehow he's being coerced or pressured. And the judge will ask him, Are you doing this of your own free will? Is this still what you want to do? Right? Before he ultimately says, I accept your guilty plea, he'll give him another opportunity to say, you sure you don't want to go to trial? Sounds pretty cool and all. You sure? And if he says, no, I want to plead guilty because I'm in fact guilty, then the judge will more than likely accept a guilty plea. Then the question is, are they going to go to immediate sentencing, right? Everybody knows what the sentence is going to be, but they probably need time for people to be able to state, victim impact statements and things of that nature. So family members get an opportunity to vent and state how they don't like the plea deal and that he should have been, put to death and all those types of things. But more than likely, I said, I can't imagine the judge is going to reject it. If he was going to reject it, guess what? We wouldn't be having a hearing set for tomorrow at 11 a.m. All right. And ultimately at sentencing, victim impact statements are read. Prosecutors can explain why they think this is an appropriate sentence. And then the defendant will ultimately get his statement in allocution. The defendant always gets the last word before sentencing is imposed. It can be in writing. It can be oral. It can be a quick statement in mitigation. Usually a good "I'm sorry" goes a long way. But this goes back to English common law. The defendant always got the last word, so to speak, before the judge imposed penalty. I would expect Judge Hippler to, at sentencing, if they go to it either today or some day in the future, to give him a tongue lashing and say, basically, you're a horrible human being. You took these young lives for no good reason, and hopefully we'll find out a good reason here in the next couple of days. It's not going to be a good reason, but hopefully we find the reason for why he did what he did. So tune in tomorrow, ladies and gentlemen, 11 o'clock. Now, we're going to go live tonight, 6 o'clock. I don't know. We had, 6,000 people last night on our little live. We'll see if we can repeat that as well. 6 p.m. Mountain Time. We'll put up the call-in line as well so people can call in and we can talk about that case and anything else that's on your mind. All right? And remember, if you disagree with me, you get head of line privileges. Next on the docket, Barry Morphew, indicted for the murder of his wife, Suzanne, appeared for the first time on a new murder charge in Colorado today, where the court reiterated that the proceedings can be recorded by the news, but with some limitations. Now, we intended to bring you this proceeding, but we can't. Colorado, unless the court approves some sort of live streaming, you can watch it, but I can't send it to you. And I don't want Frank to be held in contempt. And I don't want to be held in contempt, and I don't want to lose my law license. I mean, I love you all. I do. But I don't make enough money to jeopardize my law license to stream Barry Morphew's court proceeding. All right? I think down the road, though, we'll get some permission to do so. But the reality of it is, chances can't do it right now. I love you. I do. Like I said, I've never been a client worth going to jail for, and I've never been paid enough money to jeopardize my law license. And don't get me wrong. I've got a number. But it hasn't been met by anybody yet. And I don't think I'm going to make it on this podcast. All right. So after a brief appearance in Alamosa, a lovely town indeed, I just did a murder trial over there 2 years ago. It was fun, I must say, and it's more fun when you win, because we did. The only bad thing was I had to sue my client to get my final bill paid. It's always a little frustrating. Don't you hate it when clients say, hey, you just walked me on a homicide case where I was going to spend the rest of my life in prison, but I was looking at your final bill and I think you spent a little too much time preparing. Okay, pay my bill or I'm going to sue you. Anyway, I got paid. Let's just put it that way. So Alamosa, for those who do not know, is about 200 miles southwest of Denver. And that marked the beginning of a do-over of the high-profile made-for-true crime case. That's right. The disappearance of Suzanne Morphew on Mother's Day back in 2020 spawned numerous documentaries, YouTube shows, and podcasts. And Barry Morphew was present in court in custody today wearing a white and orange striped jail jumpsuit. Those always look so good. So it's Morphew's second time facing a murder charge in this case. The media's interest helped lead to the downfall of the last prosecutor after Barry Morphew was first charged with murder of his wife back in 2021. The former 11th Judicial District Attorney, Linda Stanley, a frequent guest on those true crime shows, eventually lost her law license, partly because of statements that she made about the case during the appearances on some of those podcast. Now, the previous murder charge against Morphew was dropped without prejudice, which means they could file them within the statute of limitations period. But yes, that's right. There is no statute of limitations for first-degree murder, so it allowed the case to be refiled. Then Suzanne remains were found in 2023 in a shallow grave 40 miles from her home, and a 2024 autopsy detected tranquilizer chemicals that Barry Morphew admitted using in the past to sedate wildlife. Now, Morphew's attorney filed an objection to the judge's order allowing media recording of the case, and they argued that the public has a general right to observe trials, but there is no right to televise or record the trials. But the judge in the case, Amanda Hopkins, had previously issued an order allowing news media recording of the case in a preemptive order on June 20th, the day the indictment was unsealed against Mr. Morphew. Now, Hopkins said in court today that recording must be limited to this case and not disrupt other trials and hearings not related to the Morphew case. The public is not allowed to record or rebroadcast the proceedings. Otherwise, you can be held in contempt. I don't want to be going to jail. I don't want to be going to jail. Otherwise, we do it. I don't want Frank going to jail. You know, he's got young kids. We can't have that. So, one of Morphew's attorneys is Jane Fisher Breislin. She is a member on the Corey Wise Innocence Project, and she wrote in her court filing that pervasive and prejudicial coverage erodes Mr. Morphew's right to the presumption of innocence, to due process, and to a fair trial. But Morphew's attorneys admitted that the argument was now moot since the judge had already granted approval for media access. They were objecting to object. Anyway, the next hearing is set for a status conference to check in on the case for September 2nd. That's basically to see how much time are we going to need. You know, has everybody gotten up to speed yet? I mean, here we are, July, all of July, August, 60 days to get up to speed on a homicide trial. Not too bad if you have no other cases, but yeah, maybe they'll get one more continuance. Then they can proceed to arraignment. And guess what? Mr. Beller, David Beller, told the court that they are going to ask for a reduction of the $3 million bond in the case at the next court appearance. But in the meantime, that's right, Mr. Morphew will remain in custody at the Alamosa County Jail. A fine institution indeed, ladies and gentlemen. Been there many, many times myself. I love going to the Western Slope. And it's a quick little flight. You know, Alamosa is the gateway to Telluride, ladies and gentlemen. Beautiful airport, big runways. Telluride, the airport is up on a plateau, short runway, only one way in, one way out. Alamosa, gateway to Telluride. Remember that, ladies and gentlemen. Next on the docket, Sean Combs' trial. The jury has reached a partial verdict. That's right. The jury's foreperson says that the members of the jury have reached a verdict on counts 2, 3, 4, and 5, which are the sex trafficking and transportation for prostitution charges. The jury says that they are unable to reach a verdict on count 1, racketeering conspiracy, because jurors on both sides have opinions that, well, they're unmovable. So the parties were making a proposal to what they want to do in response. But one thing is clear, we will not probably hear the verdict as of today. Will not hear the partial verdict as of just yet. So both the defense and the prosecution want the jury to go back and deliberate further. The prosecution wants the judge to employ the Allen instruction charge, which is a way to put a little pressure on the jury to go back and try and reach a unanimous verdict. The defense does not. The defense wants to say, let's take the verdict that we got now and declare mistrial on the count. You see how simple that was? Remember in Karen Reed's first trial? Everybody didn't know, we don't know what to do. First, the jury said, this is what we've got. And the defense attorneys say, no, here's the plan. Let's take the verdict on what we got. Just saying. This is how it's supposed to be done. Anyway, the judge was considering both proposals, and they're basically, they're going to have a little bit of a hearing on the partial verdict. Anyway, the judge then, like I said, is going to give the Allen instruction. So let me give you the Allen instruction that the judge is going to give. This is from a federal practice book that I have. So it says, I understand that you have reported difficulty in reaching a unanimous verdict. I am going to ask you to continue your deliberations in the effort to reach the agreement. Please consider the following. Your role is to reach a verdict if you can do so without surrendering your individual judgment. Each of you must decide the case for yourself, but you should do so only after thoroughly discussing it with your fellow jurors and carefully considering their views. You should not hesitate to re-examine your own views or change your opinion. And if you become convinced it is erroneous, but you should not change your position simply because other jurors disagree or to avoid further deliberation. This case is important to both parties, and failure to reach a verdict means the case may need to be retried, causing additional time and expense. I am confident that if you approach your deliberations with an open mind and a willingness to listen, you can reach a fair and just verdict. Please return to the jury room and resume your deliberations. That's an Allen instruction, ladies and gentlemen. Then go back, try again. It was a 5-week trial. They've been deliberating a day and a half. Go back and try. Go back and try again. I get the defense. No, we want to take the verdict now. They obviously were feeling pretty good about the prostitution charges. Maybe that's it. But the RICO is the big one. And if he gets a not guilty on that, he's not going to get probation, but he's not going to go to prison forever. That's for sure. So, like I said, it looks like old Diddy, maybe he gets a walk on this one. We'll have to wait and see. The government's evidence simply did not turn out the way they had promised in the indictment. Next, a lawyer goes to prison. Why? For stealing money, if you ask. That's why. Let me tell you some simple rules, ladies and gentlemen. If a lawyer wants to keep their law license, there's 3 basic rules they should follow. All right? First, communicate with your client, right? You send them copies of everything, every pleading, every letter from opposing counsel. Yes, it adds up, but the client can then never say that he doesn't know what's going on. You don't want to abandon your client by non-communication. That's a good way to get disbarred. Second, don't sleep with your client. That's right. Sleeping with your client is unethical. It'll get you disbarred. Okay? And third, don't steal your client's money. It's a thing. I know an attorney somehow overdrew his trust account. We call it Coltaff accounts here, which triggered a reporting to the bar. And guess what? They found out he was taking money that he shouldn't be taking before he earned it. Guess what? Disbarred. Well, it's suspended for 3 years, but he's got to take the bar exam over again. Don't do it. So a disbarred South Florida attorney has been sentenced to nearly 3 years in federal prison for misappropriating more than $750,000 of his client's funds, according to the Department of Justice. John Spencer Jenkins was sentenced to 33 months imprisonment by Judge David Lebowski in Fort Lauderdale. Now, Jenkins pled guilty to misusing funds wired to his law firm's account for legal services, instead funneling the money into separate accounts for personal use. Now, according to the court records and statements made during the sentencing hearing, Jenkins accepted funds from clients into his trust account and general business account. In one case, funds were sent to him to manage an estate's distribution, but Jenkins redirected the money to his own benefit. What did I say? Don't take money that's not yours. Stealing. Don't take it before it's earned. That's misappropriation. That's also known as stealing. Don't do it. Next on the docket, this day in legal history. On July 1st, 1829, the city of Cincinnati enforced Ohio's black laws requiring black residents to register and post bonds or face expulsion, driving many to Canada and obviously highlighting discriminatory legal practices in the pre-Civil War era. Then on July 1st, 1862, the Revenue Act of 1862 was passed and signed by President Lincoln, establishing a 3% federal tax on income exceeding $600 and a 5% tax exceeding $10,000. Now, compliance with the act was poor, even though there were needs for the Civil War. And after the war, the act was declared unconstitutional, ladies and gentlemen. Unconstitutional. That's right. What did they have to do to make it constitutional? They actually had to pass the 16th Amendment, which was ratified on February 13th, 1913, and it legalized the federal income tax. It states the Congress shall have the power to lay and collect taxes on income from whatever source derived without apportionment among the several states, and without regard to any census or enumeration. This amendment granted Congress the authority to impose an income tax without the need to apportion it among the states based upon population, overturning earlier Supreme Court decisions that had obviously limited such taxation. And now, ladies and gentlemen, 3%, who wouldn't take 3%? Now it's 30, 35% for most. You can be as high as 50% for some people. That's crazy. Crazy. 3%. And I mean, that's what we went to war with, July 4th, right? The Revolutionary War. 3% tax, ladies and gentlemen. 3% on tea, for God's sakes. So how far we have fallen, for sure. Anyway, it is what it is. Pay your taxes. On July 1st, 1874, Congress passed the first federal kidnapping law in response to the 1874 abduction of Charlie Ross, marking a shift toward federal jurisdiction over interstate crimes, interstate being across state lines. On July 1st, 1923, the Los Angeles Police Department under Chief Augustus Vollmer established the first police crime laboratory in the U.S. with Officer Rex Welch as the first criminalist, advancing forensic science in criminal investigations. And then on July 1st, 2010, the Department of Justice merged with the Office of Special Investigations and Domestic Security section to create the Human Rights and Special Prosecution section, targeting Nazi war criminals and human rights violators. And in honor of the Sean Combs trial, which may be deadlocked, at least on some counts or one count, we have a quote of the day, our legal quote of the day. A deadlocked jury represents not a failure of justice, but a testament to the complexity of truth, where diverse perspectives collide and refuse to yield. And then finally, our dumb criminal of the day. Spike the booze, not the balls. That's right. Ladies and gentlemen, give a slur round of applause for James Williamson, a 57-year-old volleyball coach from Cypress, Texas, who just smashed his way into the DWI Hall of Shame. This weekend, while most coaches were busy rallying their teams at the USA Volleyball Girls Junior National Championship in Dallas, our boy James was apparently rallying shots at the bar. Picture this, James with a blood alcohol level twice the legal limit, weaving through the streets in an SUV packed with volleyballs, because nothing says responsible coach like a mobile sports equipment store on a bender. And when the cops pulled him over, his speech was slurring worse than a deflated volleyball, bouncing down a hill. His excuse? I hit a curb and I screwed up. Brilliant, James. Airbags deployed, SUV banged up, and yet the curb's the real villain here. Anyway, when pressed about his evening, James casually admitted to downing 4 to 5 beers at a bar. 4 to 5? That's not a drink count. That's a volleyball set score. Unsurprisingly, the police weren't impressed with the game plan and slapped him with a well-deserved driving under the influence charge. So here's to James Williamson, our dumb criminal of the day, who proved that while he might be a pro at coaching spikes, he's an absolute rookie at staying sober behind the wheel. Better luck next time, champ. Maybe stick to a Gatorade next time. That's all we have for you today, ladies and gentlemen. Join us tomorrow for the plea in the Bryan Kohberger matter, 11 a.m. Mountain Time. Join us tonight, 6 p.m. Mountain Time for our live show. So we'll see you then. And remember, the Constitution matters.